The only way to start your day.
Indeed it is. Getting into the third hour of Kenya's biggest conversation this Monday morning, the 26th of August. Our audiences all around the world. Yes, this conversation taking place here in Kenya, but essentially touching on different parts of the globe every morning. Thank you for being here. Our live streams up all around on YouTube, Facebook, on X, and on TikTok. And our audiences on KTN. Happy Monday and Karibu Sana. Okay, we're getting into a conversation on the fifth schedule. Dissolution, having not met things. We'll talk about that in a minute. But let me remind you about how you can get a quality university education anywhere in the world. Cradle is setting this up. And so you ask, who's Cradle? Well, coming in to make the connection between what you look for as a student and the best match for you in a different part of the world. So looking at universities coming in from the US, from Canada, from Greece, from Cyprus, from Grenada, or the UK, New Zealand, and coming together and saying, okay, all of these guys are on display. How can you get access to them? The Study Abroad World Fair is taking place on the 31st of August. That is this Saturday at the Gallant Mall in Parklands from 11 a.m. to 4 p.m. So you can come in and do a plethora of things. Apply and get admission on the spot. Get a visa consultation so that you know what you're doing, as visa officers will be there. Also, apply for accommodation and you can get that sorted. You can also apply for scholarships to pay for school. So you can imagine it's a one-stop shop for all your university education needs. One place, one time. You get there by invite. How do you get the invite? You register. www.cradel.com. That's CRAYDEL.com. You can also call 0799 000 444. It's the World Study Abroad World Fair taking place this Saturday. You want to be there and get that locked in. All right. The conversation that we are having this morning is around the dissolution of Parliament. And you ask, what? Yes. The repeated refusal to enact the fifth schedule legislation. No stranger to the room is Marilyn Kamuru, who is a lawyer and feminist, and she's here in the hot seat this morning to deliver this hot thing. Good morning, Marilyn.
Good morning.
How are you?
I'm good, thanks.
Karibu Sana.
Asante.
Things are boiling.
Are they?
Or they should be boiling
for such a long time.
They've been boiling for a while. Now, what you're doing is you're going to open the lid of the pot and let us know exactly what's happening and what should actually be done. But before you do that,
yes,
CT has today's proverb, and we're going to give you an assignment on a Monday morning. Listen to the proverb. Tell us what you think and how you would interpret it. Is that okay?
Okay.
Our proverbs for the coming weeks will be from countries of Africa that have a coastline, countries that border either the Indian Ocean or the Atlantic. Our proverbs for this week are from the Republic of Algeria. Actually, Algeria, it is the People's Republic. It's not just a republic. People's. Mm-hmm. The one whose belly isn't full of straw isn't afraid of fire.
The one whose belly isn't full of straw isn't afraid of fire.
Yes.
Okay. Wow, gosh. I mean, if you're going to be asking people these things, you need to give them coffee or something. Mine is still full. Mm-hmm. The one whose belly is full of straw. So I think that means that, if you are not, if you're not at risk, because the fire would consume straw. So if my belly is not full of straw, then I actually, that's a very, very good one for this conversation. My belly is not full of straw. I'm not afraid of fire because the fire would not consume me, right? The straw is something that's flammable, right? So I think that is about the types of people that can actually generate particular conflicts, right? Or difficult conversations. Let's even put it that way. That they are people the ones whose bellies are full of straw are not going to be having difficult conversations. Yes, hence Parliament. Their bellies are full of straw.
Okay, then.
Yes.
Well, okay. Makes sense. And jumping right into it, right? We're looking at the possible dissolution of Parliament on the back of refusal to implement the fifth schedule. let's just now start to break that down a little bit, and let's just give an overview. The fifth schedule is large. It is wide.
Yes.
It is various in nature. And maybe just give us an overview of what it means, what it is, and why are we looking at the importance of its implementation at this point?
Well, we're overdue looking at its implementation. We're 14 years tomorrow, right? Since promulgation of the Constitution. So the fifth schedule is basically a list of bills that Parliament was required to enact to bring the Constitution into force. And all of these bills had various timelines, but they were required in total to have enacted all of this by the fifth year. So by 2015, Parliament had a provision for a one-year extension to 2016, in which they could do in certain cases. So we're now talking about this, what's that, 9 years later? So Parliament is 9 years overdue. And I would argue 9 years overdue for dissolution. Yeah.
Okay. 9 years overdue to implement what exactly?
So remember that the 2010 Constitution changed our entire mode of governance. That's the whole, the people may, right? And it's often the people may, and constitutional officers shall, right? So it's really important to understand 2010 changed the entire mode of governance. I love that CT was telling us that Algeria is the People's Republic. In many ways, the Constitution of Kenya 2010 is about placing the people above. So the source of sovereign power are the people. It is not the state, it is the people. So in order to change this mode of governance, we needed to change both our laws, but also our ways of working. And the Constitution of Kenya 2010 was very cognizant of the resistance of a certain clique of the political elite to its implementation. And so what it did is it created a mechanism where should Parliament fail to enact legislation to bring the Constitution into effect, Parliament can be dissolved. In effect, saying that the people remain superior to Parliament at all times. Should Parliament fail to do what it is required to do, Parliament can be dissolved. Yes.
Okay. So, I would maybe a few examples of some of the things that were expected to have been implemented by this place and this time that we sit, that have not, that perhaps have some kind of detrimental effect on legislation.
So obviously the 2/3 gender rule, right? But also, and that is actually for promotion of the representation of marginalized groups, right? So the way the fifth schedule is it's actually based on the chapters in the Constitution. So there's various bits of legislation. So I know we've talked a lot about recall, for instance, and recall, a law on recall was one of the requirements in the fifth schedule. Again, because the Constitution was saying we need this mechanism to work, and it doesn't work if the provisions that we've put in place for accountability aren't there. So there's recall, ethics and anti-corruption, legislation on elections, electoral disputes, IEBC. So a lot of this legislation has been enacted. It's not to say it hasn't all been enacted. But Parliament has been, shall we say, actually, I don't think I even need to look for a nice word at all. Parliament has decided that they are going to create an extra constitutional and an unconstitutional mechanism where they are exempting themselves from provisions of the Constitution of Kenya, which is illegal. Right? I think the challenge with this conversation is people always say, well, if this was really true, somebody would have done something.
By now.
Right, right? And I think the challenge is that, I keep saying it's an imagination problem. We really have a difficult time imagining that our government is as hell-bent on illegality as it is.
Okay. It's very interesting. I'd want to take you back to the 21st of September 2020. I think that was the closest that we came to dissolving Parliament. It came right from the mouth of the Chief Justice then,
Yes.
David Maraga.
Yep.
But before we talk about that, the women rep position, for example, in Parliament is an affirmative position.
Affirmative action
Yes.
position, yes?
So in your view, if at all it didn't exist, do you think it would have pushed the members of parliament into implementing this, the two-third gender rule? Because part of the reason is it sort of balanced off the number of representatives in parliament. By that, we have so many women, 47, without the ones who've been elected to sit in parliament. Do you think if we didn't have the 47 elected women in parliament as representatives, they would have had that urge to, for example, implement this? Could it be one of the reasons? Because there could be reasoning, because you said it's a problem of imagination. Do you think they would have reasoned that we're still falling behind in terms of the number of women who are sitting in parliament? Would it have helped in a way?
So I think you misunderstand the two-thirds gender rule. The two-thirds gender rule is not about an at least number of women. The two-thirds gender rule is actually a provision that restricts the dominance of either gender. And two-thirds is actually a theme we see in our constitution. You require two-thirds majority to overrule things. You require two-thirds majority for a constitutional amendment. So two-thirds is about dominance. It also comes from the very same place as our, what do we call it? Our counties, right? Because what this was about decentralizing power and not concentrating power, either in the executive or in a central government or in the hands of a minority majority, which were men, right? Because that was what happened. So I don't like to, I don't think it makes sense to engage on the women rep position and the two-thirds, because what the two-thirds was meant to do was make sure that you never had any one group in such a supermajority position that they never needed to deal with a minority, right? So it's really not about at least number of women. It's, have we created a system where there's a level of checks and balances within the system that can restrain it from going overboard in whichever direction?
Actually, I think you understood my question and I didn't misunderstand the two-third gender rule. I think the explanation is totally correct. Your explanation is totally correct. But my question is this. The members of parliament, because we have a difficulty with members of parliament, that is where the problem is.
No, we don't.
Why is it that it's been impossible then to pass this legislation?
You know, that's a very interesting question, Ken, because you would never say, why is it impossible for parliament to vote to approve cabinet secretaries? It's their job. It's not impossible. They just refuse to do it.
Then
right? So it's not impossible.
That is my question. Why have they refused to do it?
Do you know why they've refused to do it?
Tell me.
They've refused to do it because there have been no consequences to Parliament's illegality. If there was a consequence to Parliament's illegality, they would have done it.
Who would?
And the
Now September,
consequence
yes.
to illegality,
Yes.
the only consequence
It's
in the
dissolution.
Constitution is dissolution.
Now take us back to where I started. David Maraga writing to the president asking for parliament to be dissolved on that account. It didn't happen. For me, that was the closest this would have happened.
Okay, so when Chief Justice Maraga wrote in 2020,
Yes.
he had already been under an obligation to write since 2017 because Article 261(7) that we're talking about does not require the Chief Justice to be petitioned by anyone to dissolve Parliament. I don't need to write, you don't need to write, nobody needs to write. In fact, the reason 261 exists is because the Chief Justice independently is under an Article 3 obligation to uphold, protect, and defend the Constitution of Kenya. So when Maraga in 2017 did not write to dissolve, I was among some people who petitioned him in 2017, right? 2020, these petitions started in 2018. So 2018, people petitioned. 2019, people petitioned. 2019, he dissolved Parliament, right? Or
he wrote,
advised the president to dissolve Parliament. And actually, I'll tell you what happened then is Maraga, check, constitutional obligation delayed, but check. The failure was the president did not dissolve Parliament. That was an unconstitutional act. And our constitution actually provides that an omission can constitute a violation of the law. So it's not just an act, right? So the president unconstitutionally failed to dissolve parliament.
One must ask, though, and I think I'm going to stick on to what Ken is asking here, is that the why must be looked at and dealt with. Because you know what? Dissolve parliament and almost 400 people go home, right? Now, go back, fresh election, bring people back. There is no guarantee or surety that these individuals who come in will implement what is required by law, by legislation. So I think it is necessary to look at the overarching, in this case it might be underwater reason, as to why this thing is being done. Because there's an understanding across board of what your job is. Nobody can tell me that these individuals don't know what they're supposed to do. I'm sorry. Maybe for dealing with kindergarten-going children. And maybe even at that, kindergarten children understand rote. They know they must count from 1 to 10, we move. We get it. So there must be a reason why this has never happened. And if we don't look at that, I think we're going to continue doing this merry-go-round, horse and pony show dance.
So
over
let me
and
tell
over
you
again.
something.
What is the reason
court,
why this doesn't happen?
So let's say I was a rape victim, okay? When I go to court, I have no interest in the rapist's rationale for why. It does not fucking matter.
Language?
Okay.
Okay.
There is no reason that a why, when there is a law, becomes the basis for which we're engaging. And I'll tell you why. If we were talking about this in 2013, that would be valid. Do you know why? The 2012 advisory opinion from the Supreme Court said, Parliament, you have until 2015 to enact this legislation. Okay? So if we're talking about this in 2013, absolutely, let's talk about why. Absolutely. I'm telling you 9 years later. And that's why I'm saying there's a failure of the imagination. Because when you're asking me, if for 9 years, a body that is required to enact legislation doesn't do what it's supposed to do, we should ask why. No, we shouldn't. We should implement the mechanisms in our constitution that hold that body accountable.
Who is to implement them?
So the Chief Justice in this case, and the Moraga decision, as Ken has pointed out, was in 2020. So it related to the 12th Parliament. And why this, the Chief Justice was quite clear, and I think he was correct in stating that it is, Parliament is a perpetual institution. However, the advisory is only if Parliament has not enacted legislation, right? So from 2020 to now, if Parliament again has not enacted legislation, what Parliament is basically saying is mtadu. Okay. So when someone tells you mtadu, do you ask yourself, what is the why of the mtadu?
So this is the thing. So when you look at something like this, and it's an action that doesn't happen, and it recurs, this inaction recurs over and over. Remember that this has gone over terms, right?
Yes.
This is, like you said, 12th Parliament, 11th Parliament.
11th, yeah.
Some
12th,
cases,
13th.
Some cases, totally different individuals. 12th Parliament, totally different individuals.
Yep.
13th Parliament, totally different individuals.
Yeah.
My question is, what is to guarantee that if you dissolve Parliament and all of these individuals go home and you bring in a fresh set of individuals, or even maybe the same ones, what is to guarantee that these things that we are looking at will actually be implemented? Because that's what we want. At the end of the day, the goal is to do what the supreme law says.
Yeah, and so that's why people like me do what we do, right? I don't do this for fun. I should be able to do other things. And I think part of why I find the framing of your questioning problematic is because what it does is it normalizes illegality, okay? It puts me, a citizen, in this position where I must keep explaining to the people who are the bearers, duty bearers, to people who take an oath, you need to do your job.
No, and what it is saying that if there is a reason why this thing is not happening, it is just as important as saying, get rid of it, but it is just as important for you to find out, is there a problem here? Is Kenya still heavily, if we're looking at the 2/3 gender rule, is Kenya still heavily patriarchal? Does Kenya still believe, because whether we like it or not, the people who are put in positions of parliament are voted in, right? Are we saying, what is the underlying reason here? is that in the minds of people, do they still feel that maybe we don't want to put women
So
here?
feelings aren't part of the Constitution.
No, allow me to finish my question. We are saying that the reason why people are in Parliament is because people put them there by nature of the vote. So if we are saying that the 2/3 gender rule has not been met, what is the reason behind it and how can we deal with it?
But we're getting back to the same place, and I'm telling you, our challenge is we have very different framings, okay? And I'm not saying that as a way to sidestep your question, but to explain why I don't think your question is actually a valid one. So if I go to court and somebody tells me that, hey, Marilyn, you broke the law, what the judge might ask me is, okay, yes, let's assess whether you did break the law. Let's evaluate that, right? So there's a determination of fact.
Right.
Okay? And once the determination of fact is made, then the judge might say, you know what? Give me your exculpatory reasons. Explain to me. Might. Does not have to. Might say, give me your reasons for doing this. Okay? So what did we do? We went to court and we asked for a determination of fact that the Constitution actually says what we think it says. Like, did we read it wrong? Did we make a mistake? And we went for a determination of fact. And that's what the High Court decision was in 2015. And I remember because I actually remember going to people and saying, wait a second, guys, we're almost at the end of the Constitution. I don't know if anyone remembers. We had a commission on the implementation of the Constitution. We had a body that was supposed to oversee legislation, right? So we're almost at the end of their term. And I remember talking to people and saying, guys, this doesn't seem right. We're going to 2015. There's no legislation. There's a Supreme Court advisory. I talked to Martha Karua. I talked to Judy Thongori. And Judy said, you know what? I think you're right. And we sat down with Elisha Ongoya at Intercontinental's lobby. And we looked through the Constitution. And that was the first case on the dissolution of Parliament. Because actually, it's a domino. Right? That case was in 2015, right? So that was the determination of fact of Parliament, this is what you're supposed to do. If you were in doubt, this is what you're supposed to do. After that, there was a case in 2017. And oh, by the way, there was an order. Within 40 days, you need to enact this legislation. You need to introduce. It wasn't an act, it was introduce. What did Parliament do? Parliament said, you know what? We know this game. We're not going to renew the term of the Commission on the Implementation of the Constitution, which means there's no oversight mechanism to make sure we do what we're supposed to do. So Parliament gets rid of CIC. Does introduce a bill, does not pass the bill. 2017, we're back in court. So again, courts have determined the fact of what Parliament is supposed to do. Beyond that, the Constitution gives no discretion to the courts to ask why. And I'll tell you why. In 261, the language is not introduce a bill, it is enact legislation. Because what the court envisions and what the Constitution envisions is between this entire time, Parliament should have been explaining, this is our difficulty. Gone to the Office of the Attorney General. They should have been explaining why this is not possible.
Okay, we're going to go to a break, but let me ask you one question. In a very simple form, does dissolution solve the problem, which you've clearly explained? There's a problem. Does dissolution of Parliament then solve the problem?
Yes.
How?
Because I am a firm believer in the Constitution. It is the only constitutional remedy provided. Do you know, by the way, that the Ruto administration was very clear that they were subject to dissolution? One of their political promises was they were going to enact this law within, I think, initially it was 90 days, and I think after that they said a year. So they knew the risk. So this isn't something that we're talking about that is far-fetched and archaic. And oh, by the way, I do think we're going to dissolve Parliament. We're just going to dissolve it when the political elite decide it is convenient for them.
It's 29 minutes to 9 o'clock. Let's take a break on this point. We're looking at the fifth schedule and implementation of parts of the Constitution. At least by now, we're going to come back and continue that in a short bit. Let's take a look at traffic and weather. Be back.